Well, thank you for joining me this month at the Rafi webinar. We're going to talk about the good, the bad, and the ugly of my last trial. I'll start with the spoiler alert. We did not win, but we didn't lose. Always a tough way to start, that we didn't win, but save it with a we don't lose. And I'll explain what I mean by that in just a few minutes. But I want to tell you all about this case that we tried. It was the first case that I had tried since COVID. Handled 2 or 3 bench trials that we decided to do in various cases for time reasons, where we decided to do bench trials in cases and the defense agreed. But this was my first time back in a courtroom. I'll tell you a little bit about the facts of the case. I'll tell you how COVID made things strange in this trial, at least tougher than what I was used to, and connecting with jurors was much tougher. I'll run through some of the good and the bad that happened before I got involved and after, and then I'll talk about the trial and hopefully answer any of your questions. My offer is true, honest, and valid. Please, 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 if you have questions, thoughts, comments, drop them in the chat here. That way I can answer them and talk to you. I want to make this as valuable as I can for all of y'all. And I know my case. I know the case. So in the next 50 minutes or so, I want you to get to know it, and I want y'all to tell me what I did wrong, what you would have done, what questions you had, why I did something. If I don't explain it, please throw that all in there. So this was the oldest case on the Athens-Clarke County docket in civil court by a few years. This case stems from a fire, a house fire, that happened in 2013, a house fire that happened in 2013. I came in on the case June or July, I think, maybe July or August, something like that, of 2021, this year. So this case had been pending for 8.5 years by the time it got to trial. Y'all are probably thinking, well, this must have been an appeal in the middle. Maybe there were 2 appeals, not a single appeal. Not a single appeal. Bunker, my dog, just went, rah. Even he's like, what the hell? This case just sat for a long time. The first lawyer handling it either retired, I think retired, and the client was kind of in a bad spot. Another lawyer took over, and just not a lot happened. It kind of sat there. So I come in June or July, whenever it was, and I'm learning a case that's 8 years old. Thankfully, not a ton had happened. Thankfully for me, not so thankfully for the case. When I get a new case, especially one that's already being litigated, first thing I'm trying to figure out is, what am I missing? What am I missing, and can I go get it? So here I'm trying to find witnesses, literally, and I'll tell you a story about finding one. I'm trying to find witnesses 8.5 years after this has happened. One witness, I was told, has moved to Africa. So, that witness was in the United States for 6, 7, 8 years, and then moves to Africa, and I lose that witness. And that was an eyewitness to the fire. So that really, that hurt. But I get this case, and one of the first things we do is we have a pretrial hearing. And I mentioned my theory of the case to the judge, and he kind of chuckles and says, well, that's nice, but you can't say that. And I said, why can't I say my theory of the case? And he says, read my motion for summary judgment from 5 years ago. And I did, and I still didn't get it. And essentially, he had granted partial motion for summary judgment and had excluded more, the order at least excludes more than I think he intended. Or at least excluded more than I thought it should be. So we actually were on a trial calendar for the summer sometime. My concept of time is so bad. But we were on a trial calendar and number 1 to go. And the judge actually gave us 60 more days, gave the defense really 60 more days of discovery after 8.5 years, because their argument was that my theory was new and had never been made. Maybe it had never been said out loud, but it certainly wasn't a new theory. But anyway, we had 60 days that we got pushed, and then we went and tried this case. It was 90 days eventually by the time we got to try the case. The facts were that my client is in Athens. He is hanging out with some friends, and he calls up his buddy. And he says to his friend, hey man, I got some stuff I want to talk to you about. I went all sideways with my girlfriend or fiance at the time. Can I come over and talk to you? And his friend says, yeah, but I'm at work. I won't be home until 2 or 3 in the morning. He works a restaurant night job. But you can go in. Why don't you, here's where the key is. Just go into my house. I'll meet you there. So my client walks to another friend's house, smokes some weed, and then walks to his friend's house. They talk on the way. There's another call in the meantime. But when he gets to the friend's house, he goes to the side door, which is a basement entrance. Upstairs, this is a residential house. Upstairs, we were calling it one apartment, and downstairs in the basement was a second apartment. So first floor apartment, basement apartment. That's what we said about this house, and that was actually an issue in the case. I'll tell you why in a second. But my client walks over there. He grabs the key from wherever it was. Nobody remembered where the key was 8.5 years ago, but he goes in the basement. The basement looks like you like this drama? The basement looks like this. I'll give you all a second to get oriented, whatever that word is. But he, on the left here where it says door, that is where he walks in. There's a fridge on the right and a bathroom on the left. All the other space around that is finished space, drywalled space, but nothing's really in there. Through this entranceway right here, this is actually the bedroom. I'll highlight it all if I can. This is kind of like a bedroom suite, if we can call it that. But when you walk in from the left, you have a washer and dryer on the left side, a TV on the right side, and then a sofa on the back left corner, which actually is really pushed up against both walls, and a bed on the back right corner, which is pushed up against both walls. This drawing makes it seem like the room is bigger than it is. Apparently, there was about 3 to 4 feet between the sofa and the bed, which were touching the opposite wall. So very, very small space. Between the sofa and the washer and dryer was about 1 foot or 2. Same with the bed and the TV. So very, very small space. It is February of 2013, and it is cold. It is cold. So when my client, whose name is Frazier, and I'll call him Frazier, when Frazier walks into that room, he is cold. Not just because it's cold outside, he's cold because there's no heat downstairs. There is no heat downstairs in the basement, and there hasn't been heat for a decade plus. Nevertheless, the owner of the house is renting this out. Now, here's where it gets a little tricky. In 2008, the owner of the house passed away. In 2008, the owner of the house passed away. Her daughter takes over the responsibilities for the house, but does not change the title, does not change anything, doesn't even change the insurance policy name. So the house, I guess when the case first started, there was a question of who the heck you're going to sue, because the house is owned by somebody who has passed away. So there was a lot of briefing about that issue in this case. But ultimately, I think we got the right people. In the end, we sued the estate which got set up of the person who died in 2008, the former owner. So we sued the estate, which I think was the right defendant. That eventually became the right one. And also the owner of the house individually, the new owner of the house individually, even though she didn't technically own it in 2013 when the fire happened. I don't think she was the right defendant. Okay, so we have the estate, which I think is the right defendant, and the individual now new owner, who I don't think was the right defendant. All right, so yes and no. I'll get back to that in a second. But that new owner is leasing to her niece upstairs and her son in the basement. My client, Frazier, is somehow related to all these people. So literally, this is a family dispute, essentially, involving an insurance company. It's a family dispute where the insurance company has all the money. So Frazier walks in here, and he is ice cold. If you see this star right there, that is an outlet, a plug. That's what it says upside down, but it's a plug for an outlet. If you look at this box in front of the washer and dryer, that is a space heater. That is a space heater. And if you look at this H, that is a second space heater. What my client knew was that there were 2 space heaters in the downstairs apartment. One of them had a short in it and one of them did not. When he walks in, he goes and gets some snacks. He turns on the TV and he watches Adult Swim because, well, he's high. So he sits on the end of the bed and just sits there. You can see him, he drew himself during his deposition, laid back. And that's how he says he fell asleep. But at some point before he falls asleep, he hears a humming noise. That's what he hears. And when he looks on the sofa and he sees a heater, I'm highlighting it right now. He sees a heater on the sofa. It's tipped over, a space heater on the sofa, tipped over, and it's humming. He goes, oh shit, I gotta get this space heater off the heater. He jumps up, he pulls this crate, which is a like wooden milk crate. He pulls it over to where the H is. He puts the heater on top of the crate and he goes to sleep. The other heater is not plugged in. Frazier wakes up a short time later, we don't know how long, but he wakes up and he's on fire. He's on fire because the whole room is on fire. The sofa, the bed. He jumps up, takes off a jacket he's wearing because he's cold. He tries to pat down the fire. He runs into this bathroom where the sink is leaking and there's a bucket under the sink to catch the water. He takes the bucket of water and he throws it on the sofa where the main part of the fire was. When he does that, the fire is about to be out, and all of a sudden, out of this plug, this outlet, spews a flame. I mean, it's like a gun shooting fire out, and then the whole place goes ablaze. Frazier runs upstairs. He gets out. He actually runs upstairs out the side door here and goes to the neighbors, says, call 911, call 911. He then looks in the driveway and sees a car, and he realizes that's the upstairs tenant's car. He runs back into the house, which is now totally on fire now. He breaks down the front door with his shoulder, goes in, and he pulls out the upstairs tenant and her two children, carries them out, literally like movie superhero, carries them out of a fire. In the process, he's getting burned, and he has really, really bad burns on his hands and his feet. Burns on his hands, I think, were from before he left the house for the first time, because the fire was coming up his arms as he was in bed. The fire, or the burns from his feet, I think, are more from running back into the fire, although that argument never got made that the burns on his feet were his fault. That's a tough argument to make when you save 3 people, but that's what I think. So that is literally my case. And you're probably thinking, what the heck? This is what I thought when I first heard the case. Why in the world do you think someone did something wrong? Well, the Athens-Clarke County Police, or Athens-Clarke County Fire Department concluded very quickly that the reason the fire started was because when Frazier put this heater near the sofa, he put it too close, it set the sofa on fire. And that was the working answer for the Athens-Clarke County Police, as well as the defense, until sometime after the fire investigation, when the insurance company hired their own investigator. And that investigator concluded that the fire was from a cigarette that started the fire. Their theory was that Frazier fell asleep while smoking, and that a fire started because of the cigarette that he left on, or that he didn't put out. So there was a conflict, and I did not know until, until a week or so before trial, which theory the defense, at least I couldn't guess. I couldn't even get an idea of which theory the defense was going to go with. I didn't know if they were going to go the fire inspector route or their expert route, because the two could not reconcile. So that was one tough thing. The toughest problem that we had is that we had no idea how the fire started. I had no defense experts, no theory of how it could have started, at least no scientific theory, no expert witnesses, no nothing. So that was the problem here. And that was my biggest fear. That's why walking into the trial on the first day, I was kind of resigned to the fact that if I couldn't prove how the fire started, that I would not be able to win. The evidence that we had to support how the fire started was, we said there were 3 ways. The first way is the fire inspector was right. The heater did start the fire. Probably thinking to yourself, well, if the heater started the fire because Frazier put it there, then isn't it his fault? Sort of. In Athens, Clark County, as well as almost every county that I found, so I did research trying to figure out a few things about these type of laws. But Athens, Clark County has a rule, as an ordinance, that says that if you are a landlord and you are renting space, you have to have it heated above a certain temperature. So you doesn't care, it doesn't matter how you have it heated, but it has to be above a certain temperature. On that night, I think the temperature was like low 30s, and the inside was, the inside of the basement was ice cold. So one theory we had was if the landlord would have followed the law, and this was actually our theme, if the landlord would have followed the law and there was heat, there would have been no fire because space heaters wouldn't have been used. So even if Frazier caused the fire with the space heater, then he shouldn't have been in that situation in this small room where he had no real place, no real spot where he could put the space heater. It was kind of like a trap, essentially. Anywhere he put the space heater was too close to something, but he had to stay warm. So his choices were space heater and warm, or no space heater and be ice cold. The second theory we had was that it was an electrical fire caused by the outlet. The evidence that we had for that was after Frazier threw water on the outlet, that it sparked and it shot out like a blowtorch. That was tough. The third theory that we had was that it was an electrical fire in general, not just for this outlet, that it was an electrical fire in general. We had some evidence for that. Our evidence was that there was some testimony that the downstairs tenant who invited Frazier over, that I'm reading this joke that someone put in the chat, and forgive me, but it ends with tasteless. Okay. So anyway, our third theory was that that there was an electrical fire. There was some testimony from one of the tenants that there were electrical issues in the house, that outlets were worn out and would spark, that there had been electrical problems that hadn't been fixed. And that's about it. So really, I focused the case on trying to prove that Frazier did not start the fire, with a catch-all of if there was heat, then this wouldn't have happened. So at this point, my lights keep flickering, which is strange. At this point, I'm going into trial and I'm really worried. I mentioned a witness that I found after 8.5 years. And not only did I find him after 8.5 years, I found him the night before trial. So there's a witness who was the downstairs tenant, not an eyewitness, but a witness nonetheless. And he was my notice person. He was the only person that testified there had been prior electrical issues. So I went and found him at his job Sunday night before the Monday trial. I talked to him. I gave him a subpoena. He'd actually already been served earlier that morning. That's how I knew where to find him, but we had been looking for him for weeks. Gave him a subpoena, explained to him that I need him to come to trial, and tried to explain to him the questions I would ask. The problem here is that he would be testifying against his mother, who's the owner of the house. Against his mother, who's the owner of the house. That wasn't the main problem with this witness, though. The main problem was that he couldn't tell a cohesive story. And I don't think he lied. I don't think it was that he wasn't telling the truth. He's one of those witnesses that whoever talks to him last, he's going to agree with. Literally, whatever you tell him, he's going to agree with. And if somebody else comes and tells him something that's directly contrary, he's going to agree to that. And even in his deposition, when the plaintiff's side was deposing him, he was a great witness. And then the defense does their part, and he says the exact opposite. So he was my star witness. Think about that. He was my star witness. I did record him while I talked to him on that Sunday night. So I was able to, say, hey, you just told me this yesterday. But he had given an affidavit at some point, which was literally the exact opposite of his deposition testimony. So, when I'm saying that there was problems with credibility, it was really tough. But the things that he said that were positive for our case and in a way negative for his mom, I thought those things were really powerful because he had no reason to not tell the truth or say things for his mom or say things against his mom. So I thought he would, if I could get him to stay in the lane that he said, at least in part of his deposition, I'd have a chance. Let me talk to you about the actual trial here and some of the ways that COVID affected it. The first way was that we had jurors extremely spread out in the courtroom, which I didn't think would be a big deal. I mean, I knew this was going to happen, but we tried our best, and the judge allowed us to I think we put 40 people in the room. My strong preference for jury selection is to have all the jurors, assuming you can, in terms of how many strikes you expect. But a case like this, we didn't expect a lot of witnesses or a lot of jurors to be stricken for cause, although there were a good number. But we wanted all of them in the room at the same time. I don't want to read from a script and ask people to raise their hands and then have the other side do that and then follow up with my specific question, juror by juror. I don't want to do that. If you haven't watched my jury selection webinar, it's on YouTube. It's something I can do again, but I want everybody in the room at one time, and I want to ask questions to everyone in a group setting, and I want to make it as free flowing of a conversation as I possibly can. I want the jurors to say their opinions. So we convinced the judge to get 40 people in a courtroom in Athens, Clarke County, and we spread them all out. So when I am standing in front of, let's say, 12 or 15 jurors, there's 15 in front of me. There are 15 diagonally, and there are 15 to my left side and behind me. The rule I always try to stick to is don't turn your back on a juror. That was almost impossible here, because at least if I was facing forward, 85% of my back, 75, something like that, was to the jurors over there. It was also, I'm wearing a mask the whole time. All lawyers had to wear masks the entire time. Witnesses could take off their mask behind the witness on the witness stand because they were behind plexiglass. So making sure that I enunciated, didn't speak too quickly, and that everyone could hear me. That was really important during jury selection, especially, and throughout the whole trial. When the trial started, it was essentially the same setup, but a hair worse. We had 6 or 7 jurors in the jury deliberation box, or the jury box, and we had 7 jurors in the pews. So we had 2 or 3 rows of jurors, literally, forgive me, that's my Catholic word here, pews. I don't know what y'all call them, but the rows in Athens, Clarke County, old school courthouse, wooden benches, pews, whatever. So I had, there were jurors everywhere. When the witness stand is essentially in front of you, we were in a big courtroom. I was probably at some points 30, 40 yards away, probably 30 yards away from the witness, to make sure that I was behind all the jurors, so that the witness, when I was crossing and directing witnesses, so the witnesses had to talk all the way to me 30 yards away, pretty much in the back of the courtroom. And this is a long, deep courtroom, very similar to a church setup. If you haven't been in there, it's beautiful, by the way. But to make sure witnesses are loud. So volume was not a problem, but volume was a consideration and an issue that had to be addressed throughout the whole trial to make sure everyone could hear each other, especially with the witnesses who are in a plexiglass box and not used to talking in a microphone. And lawyers, anyone in the well or anywhere around the courtroom, we didn't have microphones. We did during jury selection, but we did not for the trial, and I'm glad. I didn't want to talk into a mic. Jury selection. My takeaway is that people in Athens hate their landlords. That's literally the takeaway that I had. I mean, it was almost an uprising during jury selection against landlords. And sure, I'm being a little dramatic, but not much. The comments that people had about landlords, while 3 or 4 landlords were jurors, people who were landlords, were potential jurors. People were, all against landlords. I think 3 or 4 jurors were struck because of their hatred for landlords. And I don't think it was put on to try to get out of jury duty. We had 1 juror who did that, but the opposite way, I could never find for a tenant. But there were some deep opinions about landlords and tenants, and I guess I underestimated that in a college town. It didn't really cross my mind. But jury selection, I thought went very well. I could not have imagined getting a better jury that was sympathetic towards tenants, and we were able to tell them, sort of tell them, although I said it in jury selection, that this case involved someone having a basement apartment with no heat and it being very cold. And I mean, it was immediate that the jurors were very against the landlord. I thought the landlord didn't do a particularly great job of coming in and looking sympathetic. What I mean by that is the house. I was trying really hard not to show the exterior of the house throughout the trial because it's not a very nice house, and I was worried that jurors would not want to award a lot of money, and because awarding more than $100,000 would probably be more than the house was worth. But then here comes the landlord, dressed in pearls and looking like she's just going to a fancy dinner. So I didn't think that helped her. Trying to think of anything else during jury selection that I thought was interesting. I got a bunch of objections during jury selection, but the defense lawyer told me afterwards that it was really just a throw us off, because I thought he thought, and I did too, that we were making good relationships with the jurors. What I tell jurors, by the way, feel free to steal this line. I stole it from somebody a long time ago. But what I tell jurors, that the secret to get out of jury duty is to express your honest opinions. Because if you don't express your opinions, you're going to end up on, we're going to look at our notes, and you're going to end up making the jury, because we don't know anything about you. So we assume you're a safe choice, that you're somebody who doesn't care, you're just going to be a follower. I tell them that. And I say the secret to get out of jury duty is to express your opinions and tell us, because if we find out something about you, we'll be able to decide if you're fit for the case. So save that, use it as best you can. But the judge, despite the objections, the judge let me really, and I don't try my case, but he really let me tell the contentions, the claims that both sides had. And in doing so, it allowed me to give background to the jury. There were 3 or 4 jurors that said, based on what I know right now, I am never going to find for the landlord, and the tenant should win automatically, because the law was apparently violated. So I mean, I got into all of that during jury selection. On the one hand, it's great because the jurors are really introduced to my case. They know a lot of the issues. On the other hand, 3 or 4 jurors were struck, and that they would have been very sympathetic. But in the end, we had some very good jurors, very, very good jurors. So opening statements went very well, I thought. One of the big things I wanted to do in opening statements was be dramatic about the injuries to my client. I had it pulled up. I'll show it to you again. One issue is that my client only, and it's still a lot of money, but it's not a an earth-shattering amount if you're in this kind of world, in this business. But $62,000, $63,000 of medical bills. His burns, he's a black guy. His burns didn't show up that much anymore on his hands and his feet. And he walked into court looking fine. Our client did. He walks into court, he's looking fine, walking around, speaking. He's okay. And And as a result, I'm worried about the damages number. So during opening, I really went through the fact that he woke up on fire, how difficult it had been, how the burns were, and we were really focused on damages witnesses. And I'll talk to you about that because I thought we did a really good job with damages witnesses. Excuse me for 1 minute. Nose is running here. Corey says, anyone's lights or power going in and out? Mine were a second ago during this webinar. And then what were the insurance limits, defense counsel, most recent offers before trial? That's a good question. And let me tell you about the 2 defendants and how that shook out. The insurance limits were $500,000. I think that's right. Insurance limits were $5,000. The defense counsel was Swift Curry, Roger Harris over there, and Kevin Dorsey. I actually invited Kevin. I'm gonna call him out. I invited Kevin to join this webinar because I thought it would be awesome to have him on here and talk about the things from their side. He had a conflict. I didn't ask Bill Casey because I didn't think he'd come over here, or if he did, he would just be so captivating and put me to shame that I didn't want him on. But I truly wanted the defense lawyers on here because I thought it would be awesome to hear their side of things. Most recent offers before trial. When I got involved, there was a $1,000 offer of judgment that had been filed years earlier for the defense. And I don't think there were any meaningful offers ever from the plaintiff's side because it was pretty much conveyed that there wouldn't be any money. So remember, I told you we had the right defendant, the estate, and the wrong defendant, which was the individual who didn't own the house but was the executor of the estate and really operated the house but didn't own it. I guess she wasn't an occupier. I'm thinking of the statute, owner or occupier. She was neither. So what I did was I always planned to settle with the individual defendant, the wrong defendant. I had said to her lawyer a couple, weeks before the trial, hey, can you throw any money my way just to get her out? And he said, yeah, I can throw you $5,000. And on the week before trial, he made the $5,000 offer. And that is free money because I think she's out on summary judgment or directed verdict. I think she should have been out on summary judgment. But what I did was I did not accept the offer. I didn't deny it. I just let it sit there. So after opening, I called the individual defendant. I called her as executive of state and individual, and I crossed her. And I thought it went very, very well, and I don't think she came off sympathetic. After that cross-examination, after my part, after I was done, I then accepted the offer, the $5,000 offer. As you can imagine, that caused a little hubbub on the defense side, trying to figure out what was going on, and we took a break. I was also trying to get her lawyer. She had an individual lawyer. I was trying to get him out of the case. I was hoping that judge would come in, say that there was a settlement. The plan was hopefully the judge would, we tell the judge of a settlement, judge would tell the jury, hey, there was a settlement, or this person was, whatever language we decide on. And then her lawyer would go away. He was an Athens-based lawyer. He ended up joining the defense side, but I still think it worked fairly well where judge comes back, jury comes back, and I forget the exact language we agreed to, but I think it was the word resolved. And the judge says to the jury, after the testimony, we took a break, and during that break, the individual defendant, her case was resolved with regards to the plaintiff. I wanted the jury to know that the cross went really, really well and actually see it, and then have the defense, hopefully the jury's thinking, wow, that cross went really well. Now the defense is at least offering some money, and they're gonna, that defendant is so worried they're gonna throw some money. So that was kind of what I was going for, and it worked, except the defense lawyer joined the other defendant's team. Regarding the defendant who was my target, after the close of evidence, but before closing, it's amazing my mind how it goes away now 3-4 weeks later, but we entered into a high-low with the estate. I had to think about this in my head. We entered into a high-low with the estate. So that is why at the beginning of this webinar, I said we lost, but we did not totally lose, or we didn't win, but we didn't lose. And that was because we entered into a high-low. So spoiler alert, there was a defense verdict after 5 or 6 hours of deliberation, where everybody was convinced the jury was deciding on a number. But they spent 5 or 6 hours, whatever it was, to come back with a defense verdict. And so we got the low on the high-low. We negotiated that high-low for, I don't know, a couple hours back and forth that night before closing arguments. And, at least it got my client something. Certainly not a win, but not a complete loss. So hopefully that answers your question. Michael, thank you for the question. Excuse me. Man, can't deal with this weather lately. It's got to be hot. It's got to be cold. It's got to pick one. Just pick one. Give my throat and nose a break. So the first witness that we called was the individual who we had sued, as well as the executor of the estate. And I thought the cross-examination went very, very well. She essentially, she essentially admitted that she knew there wasn't heat, or she did admit she knew there wasn't heat. I think she agreed that there should have been heat, and she agreed that space heaters are dangerous and that she was worried there'd be a fire because of the space heaters. We couldn't do any better than that. At least I didn't think. The second witness we called was that guy I met at his job the night before, her son, and he held fairly strong about, I mean, he was very strong about the prior, that he told his mom that there were electrical issues. He went through all that. He did backtrack on a few things, but for the most part, he went really well, much better than I had thought. So here we are, 2 witnesses down. We've got a good jury selection. Thought we had a strong opening. We've got a great first witness that the cross at least went well. Second witness hung tough, didn't expect that. And at trial, I'm smiling because I'm starting to believe. Not that I didn't believe before, I didn't, but I convinced myself I had. But I'm really starting to believe right now, really starting. The third witness is our client. He does really well. He's likable. He is personable. He's well-spoken. Most of his direct is about his injuries and about what happened that night. His cross is all about that drawing I showed y'all. They're tearing into him, and he's doing a great job. I'm sitting there at the end of his cross, and I'm like, wow, this is going really, really well. So the next witness is, and I forget the order we did this, but it's his mom, his father, his brother, his son, and our client's ex-fiance, the one he was having problems with that night 8.5 years ago, or had an issue with and wanted to talk to his friend. And our damaged witnesses were awesome too. He had second-degree burns, and his family all came down. They either met him in Athens at the hospital, or he was transferred that night to Augusta to a burn center. So different family members are meeting him at different hospitals, and each family member has a different story about them. What we tried to do was each family member told a different story about when they first saw his burns and saw him after the fire, a different story about something that happened during the 8.5 years, and then a take on what he's like now. We didn't want witnesses to be stepping on each other, telling the same stories. So for example, his son, who's now in high school, 8.5 years have gone by, he talked about how him and his dad used to play basketball and video games, and that his dad can't hold a controller now and can't shoot. His dad was really good at basketball in high school. So we tried to put people in different lanes, and we did a very good job. His ex-wife or ex-fiance, whatever you want to call her, she was awesome. She was awesome. And I think that ex-wives, exes, people that are no longer your friends, those are really, really powerful witnesses, because I've had a witness, an ex-wife, come into court before and say, yeah, I hate him. I hate the plaintiff. He is a jerk. Our marriage ended not very well. I hate him. But he's a really good father, and he's really hurt. And he's really upset he can't play with his kids because his back and neck hurt. I've had that, and that's been an extremely powerful witness. So I thought that his ex-fiance, who's also the mother of his children, that's why they stayed in contact. She was a really good witness. So we close, and I am pumped. I mean, really, I'm pumped. The lawyer I tried the case with, who brought me in, he joined. I handled all the witnesses, but Lauren had some great feedback and thoughts throughout the trial. Me and him are thinking this has gone better than we could have imagined. Defense starts their case, and they bring the fire inspector. I think they called their client first, who kind of said the same things that weren't really true. I crossed her again. I had a more aggressive cross the second time, talking about permission. The first time I put up the defendant, I don't think at that point that I have the permission from the jury to do an aggressive cross if necessary. Jury just knows this as a nice lady who they don't know anything about. So it was a very cautious cross-examination the first time. Second time after, our case has gone really well. I already know the jury is hardened toward the defendant because she wasn't following the law, and they were upset about that in jury selection. And it was clear she hadn't told the truth about some things. So in the second cross, I had a much more aggressive cross, still respectful. If I think I was entitled to be 7 out of 10 in terms of aggressiveness with the because the jury would have allowed that, I'm still trying to be a 5. I'm trying to be below the permission I have, because I never want to go above my authority, my right in the courtroom given to me by the jury. Hope that makes sense. If not, let me know. So after they call that their client, they call the fire inspector. If any of you did like mock trial or moot court, or I guess mock trial, it's always kind of the same thing. There's always like a police guy or some investigator. And because there has to be, because mock trial is supposed to be fair, the facts aren't supposed to dictate whether you win the case. The inspector's job, and plus it's condensed, it's a condensed problem, it's for law students or undergrads. But the inspector or police or whoever, they always do a terrible investigation. And the cross in that kind of form is always the same. It's, you did this, but you didn't do this, your inspection wasn't reliable or whatever. This was exactly that. And the fire inspector's investigation, I said, and I believe, consisted of him walking into the basement, passing a firefighter on the way who says to him, "Yeah, man, there's some space heaters down there. It looks like the space heaters caused the fire." Him walking in saying, "Yep, there's a space heater. Yep, there was a fire. Space heater caused the fire." That was essentially what he did. Basic things. He didn't know how many space heaters were plugged in, if any of them. He didn't know if the space heater had a malfunction. He, didn't know anything. In fact, there were some fuses tripped, which helped our argument that there was an electrical fire. But there were in the fuse box, fuses were tripped. And he took a picture, but couldn't even tell and didn't even know what fuses they were and what they were connected to. I mean, it was a really bad investigation. He had told me when I spoke to him, I called the fire inspector a week or two earlier before the trial, and he had told me, I expected the insurance company to do an investigation, so that's why I didn't do much. I thought that was pretty honest. So that cross of him went really, really well. And then the defense rests. So, with that context, we enter into the high-low that night before the closings in the morning. With that context, I thought the high-low was favorable for us. I thought it appropriately balanced the risk of a 0, because I kept saying to my team in the courtroom and back in Atlanta, and my client, I kept saying, hey, things went really, really well, but we still can't prove how the fire started. We might have disproved the way, but we can't prove how the fire started. So, there were still challenges, and the huge challenge that we couldn't get over was, what are we going to do to tell the jury why this fire was caused? And so we entered into the high-low with that. Thinks it balances the risk, but also the reward. We're capped at an insurance policy limits. There had not been any sort of demands set up, and I don't think there could have been. I don't mean set up in a bad way. I just mean no one had sent a policy limits demand, at least that I remember. And even if they had, I don't think it would have been unreasonable for the insurance company to deny the demand because there was so much controversy about what happened. So we do closing. I thought closing went really well. I had the statute blown up, the ordinance, and I was explaining that to the jury. One case I had before COVID, I remember, this is a different case, but I remember telling the jury how much money I wanted, and I watched the juror put his pen down and cross his arms, and I was like, shit. So that was actually the last trial I had before COVID. So here I am, and I'll tell you, I was a little nervous. So when I tell the jury how much I want, which I told them between $600,000 and $800,000. I told them that based on 3 different ways. I told them that you take the medical bills and you multiply that by 10. I did a per diem. My per diem was at minimum wage per day for the last 8.5 years. I think it was something like $600,000 or $700,000. And I suggested a per diem of $10 a day. And then the third way is I showed them And if I haven't shown it to y'all, I'll send out in an email. I know I've talked about it in other webinars, but the pain and suffering statute lists some considerations that some things the jury may consider. It's not an exhaustive list, but what we have is a big blow up of that, which has future pain and suffering written, and then a space for money. So it's almost like a bill or a check or a checklist where you would go, okay, this is one element of pain and suffering. How much? How much? How much? And go down the list. I gave them that option. I suggested to them that they don't do that because I said they didn't need to and it was too complicated. But those were the three I sent them. Talking to the jury afterwards, they said they were comfortable with what I had asked for. They didn't get to a discussion about how much the case was worth, but the jurors were talkative afterwards, and that was the word that one group, what seemed to be kind of the leaders, that the group told me that they were comfortable with how much money I'd asked for, but that they were hung up on how the fire started. And in terms of how the fire started during closing, I admitted to the jury right from the start that I was not going to be able to tell them how the fire started, but that any of the three options, it was the landlord's fault. If Frazier had moved the space heater, well, he shouldn't have had to move a space heater because there shouldn't have been one, because if they would have followed the law, no space heater, no fire. If it was an electrical fire, Frazier didn't do anything. If it was the outlet popping and having a problem, Frazier didn't do anything. If it was there were space heaters all over the house, by the way. Upstairs, there was no heat at this point too. Upstairs, downstairs, we counted 6, 7, 8 space heaters from photos. Hard to tell because some of the photos were from different angles, but there was at least 5, maybe 7 or 8 space heaters. So we thought the system was overloaded as well, and the fire inspector said that was possible. So that was another theory, which again, not Frazier's fault. Jury though, 5-6 hours concluded that they couldn't get over that they couldn't get over that we couldn't tell them that there was how the fire started. So the truth is, I don't blame them. I felt like that would be the answer from the beginning. What was kind of soul crushing to some degree was that every single part of the trial went as well as we could have imagined. And by the end, we felt really, really good. If the trial would have went how I expected it to go before day one, where it's like this, kind of weaving, I'm giving you one of these, it's like weaving down, or at least staying somewhat neutral. What it did though, was it went this way. So, and hopes obviously went up. So it was disappointing for that. Let me see some of these comments here. Did they try to parse injuries at all? No. The defense did a good job. We brought it out on direct ourselves, but they did a good job of following up on the fact that he's been working, obviously in the last 8.5 years, that he testified. There was a line where he said, he's basically fine. So they harped on that line. But no, there wasn't much dispute about the injuries. I mean, this was a liability issue. There was no billing expert to challenge bills. There was no causation defense expert, none of that. This was purely a case about how the fire started. Did you accept any portion of the fault? That's a really good question. We did not. Talked about it, but decided that even if the heater, him moving the heater and putting it apparently too close to a sofa or the bed, even if that caused the fire, our position was he shouldn't have been in that situation, that he was put in this impossible situation that he had to choose between heat or putting the space heater somewhere, and he shouldn't have had to make that choice because there should have been heat. And that's what we went with, and I felt good about that. I did feel good about that. Let's see what else we got. What was the smoke detector situation? That is a really good question. I don't know. That's a good question. I don't know off the top of my head. Defense fire expert, I forget his name, but he was one of the guys that Swift Curry typically uses, but he was not called at trial. Legally, do you not need an expert testimony on causation of fire? Good question. Good question. It depends is the answer. Of course, it's a lawyer question, lawyer answer. The jury, in terms of causation of how a fire started, that was a directed verdict issue. That was an issue that came up in a summary judgment that was filed the week before the trial. I think there was like 4 or 5 summary judgment motions filed in this case. So before trial, literally right before, I fended off 2 motions for summary judgment, 2 directed, and during the trial, 2 directed verdicts. What the judge concluded, I think rightfully so, was that if there is enough evidence for the jury to, that there was enough evidence for the jury to make the reasonable common sense conclusion that the fire was started either by the heater, or if it wasn't started from the heater, by the evidence that was brought out that it could have been a house fire caused by an electrical failure or something else, which a lot of that was actually, which a lot of that evidence came from the fire inspector, who, although not an electrician, gave a lot of opinions about electrical systems, a lot of those in our favor. So no, we got past that hurdle. And we did not need to show the exact cause of the fire. We were just trying to show that the cause of the fire was not our client, it was the defendant. All right, Michael Arndt said, in other presentations, you talk about how you give jurors a few options to calculate damages. Other folks say you need it to be authoritative. This is the answer. What are the pros and cons? So what Michael's saying is a lot of people, Mike Goldberg, for example, as far as I know, his theory is you tell the jury a multiple and you shrug and say, that's how you do this. And that's based on the idea of, I don't mean to speak for him or people who do this, but I do this in some cases. But that's based on the idea that if I think I'm the most credible person in the room and the jury trusts me and doesn't trust the defense, then I'm just going to tell them the answer. This is the answer. And they have no reason to doubt me. I do that, but I feel more comfortable kind of being vulnerable, I guess you'd call it, and saying to the jury, and I say something similar most cases, I say that I envy the jury about that they get to make the decision as who's at fault, but I don't really envy them the fact that they have to decide how much money, because I tell them that's a very, very difficult task. There isn't a right or wrong way. It is a difficult thing to do. Magically, though, if I give them multiple ways, 2 or 3 ways, somehow they always end up equaling about the same amount of money. So, here the minimum wage calculation was almost, spot on to the amount of damages times 10. And to give them a range, I used $10 an hour to make my low to high range, and the medical bills fell right in the middle there, the medical bills multiplier. So, it's not like I'm doing this without thought. I prefer to say to them, instead of the shrug of this is how you do it, I prefer to shrug and say, look, however you do this, you're going to get to the same answer. So if it's 2 or 3 ways, whatever, if you juror 7 like to do, if you're a budgeter in your house and you like to do it this way, hey man, over here, if you work an hourly job and you're more used to that, whatever you guys do, it's going to end up the same amount because that's what this case is worth. So I like to do it that way. I also generally like to tell the jury, don't award above a certain amount of money. I think that builds you credibility. And also, I think tell certain jurors that makes them think that there might be insurance here. Fun fact, after the trial, when we talked to the jurors, they just assumed that all the medical bills had been paid by the insurance company. They had not. They assumed that his future medical bills were taken care of. They are not. They assumed a lot of things about insurance because a lot of them had made claims as landlords or as tenants. And they were very, very wrong about what they assumed. And they were very surprised when I told them that, no, he has collection agencies calling him for his bills. They certainly have not been paid. That really threw them back. They thought they knew the insurance policy. And the reason is one of them had gotten med pay before in a car crash and was telling the other jurors apparently about med pay. And they all figured, yep, his medical bills are paid. And they certainly weren't. Part of the reason they thought that too was that I don't know how this came in. I know how it came in, but I can't believe they allowed me to say this. During cross of the homeowner, the estate, whatever, I got her to admit that the house was rebuilt for, I don't know, $180,000. I forget how much it was, but I got the number. She said, and I got her to agree without objection, to how much the house was rebuilt by and how quickly it was rebuilt. And part of my argument in closing, which we had the high low at this point, and we all agreed, there'd be no appeals and all that as long as there was no egregious oversteps in closing. But if there was an objection, that was okay. And when I said this in closing, the judge's eyes looked at me. He looked at me like this, and I just kept rolling, and I didn't hear an objection. But what I said was that the defendant was more concerned with getting her house rebuilt and repaired. And here we are 8.5 years later. That happened after 9 months. And here we are 8.5 years later, and my client is just begging for his medical bills to be paid. Thought that was a really powerful argument. I can't believe I was allowed to say it or wasn't objected to. Next question is, what was the defense's closing? They didn't even know, or assumptions of risk. Yeah, their closing was, he moved the space heater, it's his fault. They actually brought up a pretty good argument too, which was, he knew before he went to the house, and this is true, he knew that there was no heat because he had been there a bunch. It's his friend's place. So he knew there was no heat, so he shouldn't have went there and should have slept at his own place, which gave me a little pause. I thought that was a good argument. But essentially, they focused on, the fire inspector says that that Frazier put the space heater too close to the bed or the sofa, and he caused it to go up in flames, and he shouldn't have done it. What would you do differently at trial if you had one day? What would I? All right, I'm going to pause on the what would I do differently question. I'll get there in a second. And then the last question I see, at least, is, could I have addressed the insurance assumptions in voir dire? I did. We talked a lot about insurance, but I now am adding to my list MedPay. Maybe other people do. If you do, you're better than me. I don't think I've ever seen it either, where somebody actually talks about MedPay specifically during jury selection. I didn't talk about that directly. I talked about insurance companies paying medical bills and property damage and things like that. I did not specifically talk about MedPay. So one of the last questions was, what would I do differently at trial if I could retry it? If I had the same jury and knew what I knew, the jury concluded, what they told me was that they did not believe that the space heater lit the sofa on fire. So they said that just didn't make sense to them for a lot of reasons. And that is what I was trying to accomplish. So looking back, I did what I set out to accomplish. I disproved the defense theory, but of course we're the plaintiff and we have the burden, even if it is only 50% plus a feather. So looking back, I wish I wouldn't have thought that. Again, knowing what I know now and what that specific jury would say, I wish I would have went in there and said, yeah, the space heater caused the fire, but the space heater never should have been in that room. That's what I would have done differently, knowing all things. Do I think that's the best strategy that's going to work with the majority of juries? I don't. We talked about that argument and whether we would do it. Certainly, we didn't talk about it. That would be our only argument, but we addressed that argument during the trial. But hinging it on one argument of that really requires the jury to get past the first cause that my client moved the space heater, and to the original cause of the space heater shouldn't have been in there. And that's always a really challenging argument to make. So big picture though, knowing what I know now with that specific jury, that's what I would have done. If I had the case on day one, what would I have done differently? I probably would have somehow very early on tried to get everybody in a room. And this is before, I guess I got to give a little context. The original lawsuit was filed only against the individual who ended up being the executor of the estate, but filed against the individual. And at that point, she did not have insurance defense counsel. She had local counsel that was a friend of hers, another family member. Literally, everybody in this case was family members, except our side, the plaintiff, our lawyers, and one of the defense or two of the defense lawyers. Everybody else is related. But I wish somebody would have gotten in the room with them at that point and said, hey, This is about getting your cousin, Fraser, getting his medical bills paid. This is not, explain to them how insurance works, explain to them the law, and got everybody on the same page. And what should have been happening, I think, is that her local counsel, the defendant's local counsel, should have been sending hammer letters to the insurance company saying, pay them, pay them, pay them, pay them. Instead, this turned into a family dispute where people dug in and said, how dare he sue so-and-so, the landlord? How dare he sue so-and-so's mom? And then it's, oh, he caused the fire. And it spiraled out of control as a family issue when it really should have been everybody working together to get this claim paid. So from the start, I would have started sending letters saying, this is not what should be happening. We should all be on the same team here. You should be telling your insurance company, settle the case because you don't want to get sued. And you shouldn't care if Fraser gets money. Why do you care? He needs medical money for medical bills. He got burned while he was, so I think that that's pretty important. I also would have, conducted some depositions differently. I would have, I probably would have moved for summary judgment, as crazy as this sounds. I would have moved for summary judgment well before the trial, because I would have wanted to make the defense commit to which theory they were going to take. Because like I said, up until a week before the case or before the trial, we didn't know if they were going to go their expert route or the fire inspector route. And those were two very different arguments. So I would have tried to make them say what they were going to do. And the best way I know to do that is through filing motion for summary judgment, which requires them to show the facts that they think support. And they would have had to say, look, the fire inspector or our hired expert. So I thought that was pretty good. Who initiated the high-low agreement, and any insight on the tactics to get a reasonable high-low? I'm shaking my head because I've yet to figure out how to replicate things, strategies in different cases when it comes to money. Because if you're in this situation where you're in a high-low, there's a lot of judgment on both sides. And what I think when we entered into the high-low was helpful. We turned down a pre-trial high-low. I said no. So I think it was helpful that we did that. I think it was really helpful that the case went very well during the trial. And by the way, the reason I turned down the high-low before trial was because the low essentially was a wash after things were paid. Our client didn't really get any money in his pocket. He didn't get, after he paid medical bills and us and expenses, he wasn't getting anything. So there wasn't any risk to him to do. He was worried about the OOJ, the offer of judgment. So that was one consideration that we had. And in part, one reason that we ended up agreeing to the high-low, a later version of it, was because that got rid of any OOJ penalty. We agreed there would be no OOJ penalty, even if he got a defense verdict. So that was one thing that was really helpful. But they initiated, I believe they reinitiated it. What I find helpful to do is try to figure out what's movable. What's movable? Is the whole bracket movable? The high and the low? Is it just the high? Is it just the low? In fact, and this is all coming back to me now. In fact, we suggested a lower low and a higher high. So we suggested a lower low and a higher high, and we got turned down, and we got offered a higher low with a lower high, which I was surprised by that a little bit. It showed me that they were worried about the top end way more than the bottom end, because they wanted that top end down and they wanted the bottom end a little bit higher. They were okay with that. So, I thought that that they had some authority in the middle of their bracket, which they probably did. I made an offer to settle the case along with accepting the high-low, and we never heard back. Not surprising to me, at least. But I think you want to focus on what's movable. What can I move, and where is your risk? If you have more risk for a defense verdict, then try to move that low up, which is what we were trying to do. If there's more upside, try to move the high up and give up on the low a little bit. And the way you're going to do that is by asking questions, being straight up with people and just saying like, hey, what can move, and test them. Always test them. So if they say, the bracket can't move, this is our final offer, we'll test it once. And if they say no, they say no, you can always test it again. But if they say no, then at least you have the confidence and the surety that, hey, there's no way I can move this. This is the best offer I'm going to get. This is the best offer I'm going to get. Other things I wish I would have done differently. This sounds dumb. I wish I would have gotten a better mask for the trial. I wish I would have gotten a better mask. I don't like the ones the defense lawyers used. They were like sunglasses that were clear, almost looked like futuristic football helmets. I went old school traditional surgeon's mask, which worked fine. I was comfortable in it, but I would have somehow gotten maybe a clear mask if I could have. The plastic ones that I see aren't great, but I wish I would have had a different mask. Other things I wish I would have done differently. I wish I would have I'm trying to think of how to say this. I wish during jury selection, I would have asked, I would have had more conversation with the jurors that ended up getting struck than I did, because I think I could have had them answer questions, although I knew they were being struck very early on based on what they said. One guy, we were calling him an anarchist, kidding around. I mean, if you had any position of power in this world, you started off on a lower playing field than with him. So I stayed away from him because he was out of his mind. But I wish that I wish I would have went back to them, those 3 or 4 jurors a couple times, and gotten their opinions, because they would have been more extreme and would have made other people kind of, I think, skewed that way. I also had a weird run-in in jury selection. There was a juror who had not said a single word through all of my questions, which there was like 2 of them. First one, I said, hey, ma'am, I think you're trying to make this jury. You haven't said anything. I want to ask you some questions. And she was very nice, receptive, shy, didn't want to be there, but fine. There was one guy, though, who I asked him, and I forget what I asked him. I think the first thing I said was, sir, I don't think you and I have talked. And he goes, correct. And he's wearing a mask that looks like the dude from Batman. I can't think of the name, the one with the breathing. But that's what he looks like. That's the mask he has on. And I asked him a few more questions, and he said one-word answers to everything. And I said to him, because I felt like it was just a natural thing to do, I said, sir, did I offend you in some way? If I did, I'm so sorry. And he goes, no. And I said, okay, well, I'll give you some space. I was thrown off, though. I was really at Bane is the answer of what he looked like. But I was really, really thrown off because he looked like he was going to murder me. I mean, he was angry, or if he wasn't angry, he was just going to do this thing where he seemed to be. But I don't know what I should have done there. I felt like I needed to speak to him because he could have made the jury. I'm glad I did, because I ended up striking him, and I had the strikes to do so. But that was a weird interaction, probably the strangest interaction I've ever had. I would compare it to, if you've ever gone through Publix, through the grocery line, the cashier says to you, how was your day? Imagine looking at her dead in the eyes and going, terrible. And then she says, did you find everything that you needed? No. Well, what did you find? What are you missing? Doesn't matter. I mean, it was like serial killer creepy vibes. So that freaked me the F out, and certainly threw me off for a little while. But I think the jurors, didn't necessarily blame me, and certainly tried to respect him. It was just strange. So that was another thing I wanted to mention. Any other questions, Joe? I know I was kind of all over the place, but I wanted to touch on some topics. The point of this, from my perspective, wasn't to try my case in front of you or tell you, the facts necessarily. I wanted to show you, I had to tell you some facts, but I wanted to show you some things that I took away and things I'd do differently. It's really tough. It's really tough to have a trial go really well, better each witness and every day, and still get a defense verdict. But I think this trial should have been tried. This trial should have been tried, had to be tried. It's also a case that if I could have 100 of these, if I could have 100 of these cases, I think I'm going to win 20, 25 of them, maybe. But given the damages and what I think I can do with the damages, I would take those cases because I still think I'm going to make a profit. And I still think that cases are worth being tried, even if you think you're going to lose. And maybe that's the biggest takeaway that I'll leave y'all with. Cases, your best cases, you don't get to try them. You have a tractor trailer, a Walmart tractor trailer that rear-ended you and caused, and caused deaths. And that guy was drunk, the driver, and he had a suspended license. And Walmart hadn't run a check on him, a driving check. They had no driver qualification file. I mean, his brakes were out. You name it. You're not going to try that case. That case is going to settle. You maybe try that case once out of 10,000 times. The cases that we try are the cases where there's a disagreement, reasonably or not. I try a lot of cases, unfortunately, that I don't think there is a disagreement. The classic, the crash didn't cause that injury without any evidence showing otherwise. But the cases that we try, the cases that y'all are probably going to try, are the ones where there's disagreements. And I remember I lost a trial a couple of years ago. It was the first one I ever lost. And I get in the car in Clayton County. I get in the car to go home. And I hadn't looked at my phone. I was depressed. And I have 10 messages from people, all of my friends who are saying, my first reaction is, how the hell do you even know I lost a trial this quickly? I hate you. My second reaction, though, by reading their text is, it's nice to have people care about you. And a lot of the messages were, hey, you're not really a trial lawyer until you've lost a case. And I don't know if that's necessarily true. I think that's the natural conclusion. But you can't be afraid to lose. I hear about everybody's trials when they win, or you hear about somebody's trial that they lost, in secret at a happy hour. There's whispering, did you hear he lost? Look, I lost the trial. I think, and I'd say this to the defense lawyers to their face, I think I out-lawyered them. I truly do. I think our positions were better. I think given the facts, we did more with the facts we had or didn't have than they did. I thought we acted better than they did. And I thought we tried a better case. They had the facts, though. Or probably said more accurately, I didn't have the facts. I couldn't prove these things. Michael Arndt asked me what I do differently. Probably I missed the most obvious thing. I would have hired an expert to tell me how the fire started. And then I would have won the case. So, that's what I would have done from day one. That's the one that is so obvious. I would have hired an expert. But this is still a case that should be tried. And when you have cases, even when you're afraid of losing, you have to try that case, especially when there's nothing to lose, nothing to gain or lose by your client settling. I hear from defense lawyers all the time, well, we're offering you this money. Okay, well, when you do the math, my client doesn't pocket any money because of medical bills and fees. Why would my client ever take this? And they said, well, you can go, you should. I had a lawyer somewhat recently tell me I should cut my fee, or I should go reduce those medical bills. No, man, you should pay me more money. You should pay more money. And I have the chance to get more money at trial, so there's no real risk for me turning down your settlement offer. So those are the cases that you have to try, and you have to know and tell your client that we might not win, but your alternative is also a loss because you're going to get a settlement, but you're not going to get any cash. The risk of trying the case is so little because you're going to end up with the same result, worst case, which is nothing. So, those cases need to be tried. And when you try a case and you lose, it's okay. It's okay. If you are winning all of your trials, I think that means you're not trying enough cases. I think that means you're not trying enough cases. So what I'll try to leave you with here today is don't feel embarrassed or scared or nervous or whatever when you lose. We are all going to lose, and if you're not, I don't think you're trying hard enough, and you're probably settling cases for undervalue. You're probably settling cases for undervalue. So, when I ask for $1 million and only get $500,000, I'm going to tell you all about it. I'm going to tell everybody about it because I think we can all learn from these things. When I ask for $700,000 like I did in this case and I get a zero, I'm not afraid to tell people. Sure, it's not something I want to run around with a sign on my back saying I just lost a case. But at the same time, on a human level, sharing our failures and not just our successes I think will bring us more together. And as a community of lawyers, as a community of plaintiffs lawyers, as a community of people just trying to figure this shit out, I think it's really helpful if we all be a little vulnerable and talk about the things that don't go so well in our cases, depending on the group of your audience, whether it's close friends. Talk about the things that aren't going well in your lives. Lawyers have the highest addiction rate out of any profession, any job in the country. We have the highest addiction rate. We have extremely high levels of alcoholism, drug dependency, depression, stress and anxiety. We got to share and talk with each other. So I encourage you all to do that. I'm always here to talk about your cases. I'm always here to listen to your fears and what you're worried about with those cases in your life. I hope you figure out somebody that you can talk to about the other stuff. But in terms of cases, if I can make your job easier in some way, I'm here to do it. And I appreciate y'all listening. I'll get off my soapbox. But if I can leave you with one sentence, my sentence would be, make more mistakes. Make more mistakes. If you make more mistakes, you'll do better as a lawyer and a person, and tell people about those mistakes. Also, obviously, celebrate your successes. Don't be shy about that either. So with that, I really appreciate you joining me. I have put in the comments, oh, sorry, I guess I lost some of y'all, the internet, but glad that happened then. But anyway, if you didn't hear the last two things I said, so sorry about that. There's a link for our next webinar, which is about wrongful death cases. And there's a link to a survey. And the survey is about webinars and what you think about them, how we can improve, and how I can make this better for you guys. I really appreciate you joining me. As always, you can reach me anytime. Our office is unofficially closing tomorrow for the Braves. So if you can make it out to the parade, please do that. I think it'll be a ton of fun. Not something that happens every year, every decade. It's not something that's happened in Atlanta, besides Atlanta United, in a really long time. So everybody, thanks for joining me. I think I covered all the questions. If you got any more, I'll sit here for a few minutes and we can talk. But thanks a lot for joining me. I appreciate it.